लैन चल रहा है क्या? Anjum ma'am, please start. Rangaswamy sir and Amol sir has joined.
Okay, sir. Good evening, everyone. Very warm welcome to all the dignitaries, esteemed guests, speakers, and participants present here today on the behalf of IAMR Law College, Ghaziabad, in collaboration with the Equitas Victoria Research Center, Bihar. We are gathered here for the validity session of our national conference on the theme Paradigm Shifts in Criminal Justice System, examining and exploring the impact of India's new criminal law reforms. This conference has been a significant platform for dialogue, research, and exploration for evolving landscape of India's legal system. We are grateful to have you all join us on this virtual platform, Google Meet, on this insightful journey. To begin our session, I would like to invite all the respected dignitaries to kindly join us on the virtual platform. Your presence truly enshrines this event and inspires the future of the legal discourse in India. To present a brief overview of this enlightening conference and the key discussion that have taken place, it is my honor to invite Dr. Rangaswamy D, Director of the Equitas Victoria Research Center, Bihar. He is an assistant professor of law, Karnataka State Law University, and director of Equitas Victoria Research Center. He has presented research papers in 10 plus international and 30 plus international and national conferences and seminars. He published more than 30 articles in various law and social science journals. He is in charge of the assistant registrar administration at KSLU, Karnataka. His areas of specialization include constitutional law, human rights law, women and child law, prevention of corruption law, law and justice, professional ethics, and public international law. Sir has played a vital role in guiding this intellectual vision of this conference, and we are eager to hear from him. And now I request Sir to kindly proceed. Dr. Rangaswamy, sir.
Sir, you are not audible, sir.
Hello, am I audible?
Yes, sir.
Yes, sir.
Hello. Good evening. Sarthak, am I audible?
Yes, sir, you're audible.
Yeah. So, good evening to you all, respected resource person of this valedictory session, Amoldio Chauhan sir, principal of the college, the coordinators of the event, the participants from the different institutions, students, ladies and gentlemen. So I deem it a great privilege and honor to welcome you all for this valedictory program of the national conference organized by IAMR in association with our Aquitas Victoria Research Center. Just I am here to briefly present the profile of the AVRC. So Aquitas Victoria Research Center. So that is the group of like-minded academicians, collectively working for betterment of legal research. This is a kind of informal association of the academicians. Uh, the very purpose of the collaboration of the AVRC with various academic institutions like colleges, universities, is to strengthen academia, legal academia, and to contribute the legal research of the nation. So the purpose of collaborating these kind of conferences with different institutions, if you look into, once you visit our website, you could find out the variety of the programs undertaken by AVRC. So far we have conducted more than 10 conferences across the nation, including 5 international conferences. In addition to that, we have various publications, including around 7 to 8 books, edited books, and we are publishing
वो मिला
3 to 4 journals from our AVRC. So the very purpose is like the fundamental purpose of this kind of collaboration is like knowledge sharing. So we are bringing together all the academicians. We have invited eminent academicians from different institutions, and we have provided platform for those academicians to discuss, deliberate, and suggest some possible suggestions for some contemporary issues by organizing kind of conferences, seminars, symposia on contemporary issues. So this is one such conference organized by AVRC, so as to invite some best mind to share their knowledge and to discuss, deliberate, the contemporary or emerging issues relating to criminal law. Much importantly, AVRC is consistently, constantly striving for networking opportunities for the academicians. I am so delighted to bring this to your kind notice that we are connected with academicians across the state, across the nation. So we have our units in each and every state, and at least 3 to 5 representatives of the AVRC, they are working for different states, and that is the way we have created network of the academicians, so as to strengthen legal academia. Even we are working for the AVRC is working for a kind of problem solving entity or kind of organization. So the best example is like last year we conducted a kind of conference on environmental issues in association with KLEF College Hyderabad, and in fact we have drafted a kind of proposal to Andhra Pradesh government, so insisting, recommending certain possible suggestions for the environmental crisis faced by the state. In fact, I'm happy to convey this to this August gathering that that proposal that was appreciated by Sairam Bhatt, the professor of environmental law from National Law School of India University, Bengaluru. So that is the way. Even we, in fact, we are preparing for certain proposals to propose something for Kerala government. So we are in contact with principal secretary to Kerala government. In fact, previously he was, a principal of a Kozhikode Law College. In fact, we conducted some events with that college also. So by virtue of that relationship, even we are working on certain environmental, issues in state of Kerala. Much importantly, the third important purpose of collaborating, events with various institutions would be skill developments. I am so happy to inform you that so we have trained up many faculty members. In fact, their level of knowledge, it is not up to mark so far as organizing things are concerned, or connecting with people or connecting with academicians are concerned. So we have trained up, faculty members of the different institutions, even students at large, how to take up that activities, right from writing email to, oh, like responding to emails, and also that is the way we have trained up students by organizing conferences and seminars. So we have trained up students to take up these kind of academic activities. Much importantly, that leadership quality, so that has been inculcated like anything through these kind of conferences. Much importantly, professional growth. So as I mentioned, we have network across the nation. In fact, we have core group consisting some prominent academicians, and there would be periodical, there would be constant kind of discussion relating to certain contemporary issues, and this group, kind of professional community, so that has made that has immensely contributed for discussing, deliberating, and taking up certain discussion relating to certain academic issues. So we have many more projects in our hand. So we are working on collaboration with certain governmental agencies. We have written proposals to certain funding agencies to take up many more research projects for the AVRC. So all these efforts, So they are for betterment of legal academia, that is for, suggest some possible solutions to the contemporary issues relating to law. And that is the way that AVRC, that is working for the legal issues and legal research. So I'm so you know I'm deeply indebted to this college for extending their collaboration and providing one more kind of platform for us to discuss, deliberate on criminal law. We are so since morning many issues are discussed, dealt with by the scholars, and we will be consolidating all these things, and whatever the possible way we could suggest something to the governmental agencies, so that we will do. So I thank each and every participants who actively participated in this event, and they have presented their papers, they have expressed their views relating to contemporary criminal law issues. So those things will be consolidated, and appropriate such report will be prepared, and accordingly that would be submitted to the government. So once again, by thanking organizing college for extending their collaboration, and once again by thanking Chauhan sir for accepting our invitation, for being the valedictory program guest of this program. So once again, I thank you all. I welcome you all for this valedictory function. So we look forward similar kind of collaboration from you people, from you people in the days to come. So with this, I conclude my speech. So thank you all.
Thank you so much, sir, for that insightful briefing. Now it is my pleasure to introduce our keynote speaker for this session, a highly respected academician and legal expert, Professor Dr. Amol Dio Chauhan, Professor of Law at National Law University and Judicial Academy, Assam. Sir has decades of experience from a prestigious institution to his role at the National Law University and Judicial Academy, holding degrees in social sciences, law, and human rights. He earned his qualification from Sant J. Baba Amarvati University, Amravati, including a PhD for his groundbreaking research on negligence in medical treatment. Since 2009, Dr. Amol had been dedicated to teaching, now serving as an professor at NLUJ Assam, focusing on subjects such as criminal procedure code, Indian Penal Code, law of torts, law of evidence, prison administration, etc. I request you, sir, to kindly.
Madam, I am audible.
Yes, sir.
Yes.
Yes. Yes. Respected principal of IAMR Law College and all the teaching staff of the college, and the director of Equatus Victoria Research Foundations, and all the participants who are joined here, all the faculty members, and all the paper presenters, and ladies and gentlemen, a very good evening. So yesterday I talked with the Sarthak, and he asked me to speak on the particular challenges part. So far, this particular three new criminal law is concerned. So, friends, it is quite difficult to make the criticism on this particular three laws and to in detail as such. So, considering the time constraint, and as I know that from the in this particular conference, you are deliberating and debating and presenting your papers on various aspects of the new criminal laws, and you already that is come up with the extensive research on this particular part. So, it is very difficult to speak on this particular issue after the intellectual deliberations made by you all. Anyway, considering that, I just make the this particular idea or this particular criminal laws, what is the philosophy behind this particular criminal law. So I start the changes which is brought under the BNS, BNSS, and the BSA. So considering that, if I consider these all three laws, and if I consider the importance of this particular three law, so in my mind there are 6 points which came to my mind to understand the changes which is brought under this particular law. Now, can we think that, of course, it is my personal views, and the debate and discussion is open for you all. Can we think that the earlier or before 2023-24, the law is to rule us? Now we made the laws to establish to rule of law. So if you consider the changes, more particularly into the BNS and the BNSS and the BSA, so then you will realize that the structure of this particular criminal law is to establish the rule of law. Now, secondly, there is a shift from the concept of what we called as a colonial rule, that is Swaraj. What we called as now our journey start from if I quote that Indian Penal Code 1860, that journey start with the India. Now we are into the Bharat. So that is the change. What I personally feel, that is we started the journey in India. Now we are in the Bharat. The third objective of what I personally feel, that is there is a the proverb which we normally use, that is काल समय और परिस्थिति से बड़ा कोई नहीं. So what is that Kal Samay Parasthiti is saying, that now the time has come. Now the time and the situation is arise. We need to address these particular things into the particular law. If you carefully make the scrutiny of the BNS, BNSS and the BSA, then you will realize that the considering the that is the situations and the parasthiti which is into the India. I just attract your attention toward the changes which is made under the BNS, that is the offense of terrorism, organized crime, the mob lynching and hit and run and so on. Now, considering the technological part, as we are living into the very what we called as a developed kind of the technology, where that is we are not playing with the technology, rather technology is playing with our mind and with the human brains. Now, can we think that this particular technological advancement, instead of using to commit the crime, can we use this particular technological tools for the progress and for the development and to establish the rule of law for the common persons, for the uneducated persons, for the poor persons, for the socially and economically and the other forms of backgrounds is there. Now, in considering that this particular three law, if you go with this particular three law, then you will realize that this particular law respect to the technology, that is the use of maximum use of the science and technology. So far, the new law is concerned, the use of the technological tools into the BNSS and the BSA, which shows that our justice system will be give a speedy justice, and at the very same time, that is the stakeholders who are working under this particular criminal law will be more accountable. Now, I referring the list of the paper presenter, where I came to know that there are so many discussion and debate, and the opinion was given on the basis relating with the increase and accountability of the police, accountability of courts, and the accountability of the other stakeholders. Now, use of this particular technology will, of course, really will boost the judicial system, and the speedy justice concept will be achieved in a real sense. Now the last objective, what I personally feel, that is considering the need of the time in the procedure, in the definition of offenses, and into the terms of the punishment. If you see the punishments part, so far the BNS is concerned, where that is you may come across that the legislature increase the quantum of punishment. The legislature provide the minimum punishment, where earlier there was no minimum punishment. So the amount of fine is that is increased by 5 to 10%. Now the new concept, of course, that is the concept of the what we called as another community services is included. Now these particular aspect, what I personally feel, that is that when we are respecting to the technology, when we are that is make the journey toward from the India to the Bharat, And when we are looking for the more accountability of all the stakeholders, it is necessary to make the changes that is which is necessary to for the smooth functions of this particular law. Now, as you know, there are so many changes are there into the BNS, and I'm not going detail into the all the changes because this particular part is already you covered. I just focus on the some aspects where we are supposed to discuss for 5 to 10 minutes the challenges, the topic which is assigned to me. Now, considering the concept of the definition which is changed under the BNS and the BNSS and the BSA, of course. So the that is we come up with the concept of the gender, and of course there are some offenses where it is gender neutral, and earlier it was related only with the male or the female. But in reality, whether if you consider there are some offenses, I may be wrong or my example may be wrong. So can we think that considering the gender part, so if you think in the cases which has happened into the India now, so the husband is killed and husband is cut into pieces and dumped into the drum along with the cements, and one AI engineer committed suicide. There are so many cases which has happened. So can we really justifying? Can we really giving the justice to the gender part? Of course, that is it was the necessity of the time to provide the better protections and the equal protections to the women and the children. But at the very same time, we need to understand that particular part. Now, the most important change would what I personally feel in that so far the definition of child which is introduced under to the new criminal law, where the earlier the offense of kidnapping, abductions, or the sexual harassment cases, or the offenses related with the trafficking and the other parts, where there was no uniformity in the definition. So this is the good change which is I personally feel where the boys and girls or below the 18 years of age is protected. Now, coming to the most fascinating part of the BNS, that is the offense of terrorism, which is defined under the BNS. So earlier, it is not a part of the IPC, and you know that it was drafted in late 1860, and there was no such kind of the offenses or such kind of the what we called as a concept was not there. Now, with the passage of time, when these particular terrorist activities are boom into the world, and the peoples were facing the problem, so considering that, of course, it is a welcoming the idea. So far, the BNS is concerned. Now, so far as a student of law, so what I personally feel the what we called as the discretionary power which is given to the superintendent of police to book the persons either into the UAPA and under the BNS. So the discretion with the superintendent of police, and as a student of law, what we learn under the administrative law, if the discretion is not within the parameters and discretion is not exercised in a proper way, so that may be the problem for what we call as that may be the problem for the nations. Now, the change, what I consider that is the most challenging part so far, the community services is concerned. That is, I think, much of so many people make what we call as an opinion and suggestions on this. So, but considering though the section 4 of the BNS provide the community service punishment, and though there is no specific procedure which is given under the BNSS. Now, considering the community services part, it is totally and it is a sole discretionary power of the courts or the magistrate. And there are only 6-7 offenses where the community services is provided. It is not the new form of the punishment which is introduced under the BNS. It was earlier. It was also recommended by the so many committees and so many commissions. Anyway, but what I personally feel, if the legislature make it more elaborate and more clearly to that is why, what, for how many times, for what to extend, and what are the parameters is supposed to be followed. So far, the community services is concerned. Now, thirdly, the concept of mob lynching, what I personally feel, it is a very welcoming the step which is taken by the legislature. And the as you know, in India, there are so many peoples were killed on the basis of religion, caste, this and that. So I think that this is the a good step toward the to protect this particular kind of the people. But at the same time, what I think there may be some challenges may be there. Now, the concept of that is now the BNS under section 152 or earlier 124A, that is the concept of Raja Droha and the Desh Droha. That is the shift or the change which is made under the BNS. That is earlier it was the Raj Droha, and now we are living in the democratic state where the peoples are supreme. The government, that is considering the government, the desh or my country is superior. So this particular concept, Rajdroha and the Deshdroha, that is now we are, that is the provision says the protections against the particular kind of the activities. Now, third challenging part, or what I personally feel, because as a student of criminal law, what I think that is the use of handcuffing in the certain offenses. Though, yes, of course, there are the certain offenses which is specifically mentioned by the legislature. But earlier also the handcuffing was used by the police officer. But now the police officers is legally hello. I am
Yes, sir.
audible.
Yes, sir.
Madam, it is here is a raining, so there may be a chance of the this fluctuation of this particular.
Okay, sir.
So for the better connectivity, can I switch off my camera?
Surely, sir.
Yes. Yes. Okay, so I was discussing that this particular part. Now, what we called as the changes which is brought under the BNSS more particularly. So, as you know, that is arrest of the persons with the permission of the deputy superintendent of police if the offense is punishable below 3 years. So far, the inform and the persons above 60 years is old, so permission is required. Now again, there may be a challenge. What I personally feel, that is an a use and the misuse. That is, there is a two sides of the power which the police officer usually use. Now, considering the forensic science part, where the offense is punishable more than 7 years, so the forensic experts will be appointed, and the forensic expert will help to the police officer so far the investigation part is concerned. Now, considering I'm just focusing on to the logistic part. So far, of course, the legislature provides the 5 years time to the state to make the convenient things for this particular thing. But considering the logistic, the part of so far the infrastructure is concerned, so how many of that is how many forensic investigator and the trained forensic experts we have, and how many will help in a particular way where it is required. Of course, in serious cases, I personally also feel, because most of the time these people are flee from this particular clutch of the law because of the lack of evidences, or the scientific evidences which is not collected by the police officers and the other stakeholders. So this investigating, of course, it is a forensic investigator or the forensic expert will help to the police officer and the other agencies to collect a scientific evidences. But considering that the availability of this particular the experts, it is what I personally feel, it may be the challenge for that what we called as for the upcoming investigation and other parts. Now, considering section 530, so far this year, the BNSS is concerned, where it provides the trial and proceeding to be held in electronic modes. As that is, we all are living in a metros and a very sophisticated society, and we have so many internet facilities and mobiles and internet and everything. But what in case if we visit to the Mufasil court or the small court which is established into the very remote locations where the technological advancement is not there? So in that circumstances, it is quite difficult to manage this particular thing. So of course, it will save the time, it will save it will expedite the trial, but at the very same time, it will the considering the infrastructures part. So it is quite difficult to conduct this particular kind of the trials. Now, I skip the so many things. I just focus on to the very the important parts so far. This particular the three laws are concerned. Now coming to the police officers part, where it provides that the any superintendent of police will be deputed or will be appointed or will be designated as a special executive magistrate, and he will exercise the power of executive magistrate. Now it is also that when the police officer is an executive magistrate, of course he will be that is an IPS or the very seasoned and very intellectual and very what we call as an hardworking officer. But the power which is exercised exclusively by the executive magistrate and the power which is exclusively exercised by the police officer, when the one role when the two roles are played by the one person, so it may be quite difficult to for them to make the distinctions between the role and the responsibility between this particular what we call as this particular power which is exercised by the particular persons. Now, the another part, what I personally feel, that is as per section 187 subclause 2, where it provides, madam, I have another 10 to 15 minutes now, or can I conclude?
So your discretion.
Okay. Uh, okay, because it is the habit of the teacher to take 1 hour, so you know very well. Okay, anyway, madam. Now coming to the section 187 subclause 2, where it is provide the police officer has power to take the custody. Of course, the police custody will be of 15 days only. There is no change as such. But now considering the time period, which is that is the police officer has a power to ask the custody in chunks for 60 or 40 days. Now, of course, there is the provision that on the basis of the custody, the bail will not be denied by the court of law, and it is and as we all know, the bail is a matter of right. It is not a matter of right when the person is arrested. And if the police officer is allowed to take the custody in chunks within 40 or 60 days, so when the discretion is exercised, though these particular direct the reasons will not be put on to the record, but I think there may be some chance to what we called as it may leads toward the kind of the things. Now, coming to the Satvinder Kaur versus State of NCT Delhi, I am talking about Section 173, Subclause 1. That is the filing of the zero FIR in the light of the observations, as I told you, into the Satvinder Kaur's case. Now, we introduce the considering the science, technological advancement, and so forth. We introduce the concept of the EFIR, where the particular person has to put the signature to the police station within 3 days. But I was thinking as a student of the criminal law, so I was thinking that our peoples are more friendly to scroll the mobile screen to watch the reels. How many people are aware about the websites? How many people are aware about how to lodge the FIR and EFIR, and how many people are aware about that is they are bound to sign before the police officer within 3 days. Now, of course, the zero FIR, which is now this particular changes, what I personally feel it may be the kind of the challenge. Now coming to the Shafi Mohammed versus State of Himachal Pradesh and the Paramveer Singh Saini's case. That is section 105, which is inserted under the BNSS, where it provides the videography, which is mandatory so far the search and seizure is concerned. And the provision says that the police officer preferably use the mobile phones. That is, of course, the mobile phone which is with the police officer. Now then, I was thinking that what in case of the security and the privacy and the intervention, maybe there may be a chance of the more cases will fall under the IT Act, because when the police officer is making the search and seizure and he is videographing that particular thing, so the maintenance of secrecy, privacy, and the other part is very challenging for that particular police officers. Now there are so many changes which is brought under this particular the criminal laws. Now what I personally feel, considering the technological advancement and its use, so how many people are aware about the technology, how many people are aware about the use of that particular technology in a proper and in given time. Now new offenses and the new terminology which is used under the law, so it is also the challenging to understand and challenging to interpret in that particular way. Now, as I told you, the conflict with UAPA and the BNS, so far the offense of terrorism is concerned, the punishment part, so far the community services is concerned, and the most important thing is that whatever the observations made by the Supreme Court of India and by the various honorable high courts by time to time. So this particular I think that this particular so many judgments is not considered so far the this particular is concerned. Now the most challenging part is that is the case backlogs. That is, we have the so many case backlogs. If you go with the statistics, so lakhs of cases are pending, that is which will be go as per the old law, and the thousands of cases are registering on every day which will go as per the new law. So the hotspots may be with the judges, the advocates, the police, and the other people, so other stakeholders. So can we think that, or can we say, I may be wrong, that particular the backlog will be increased, or the judicial system will, or the other stakeholder will work very slowly. Now, considering the another challenge, what I personally feel, that is the court practice. That is, you know very well, the court practice is we are based upon the traditional methods, that is pen and paper. Now we are come up with the science and technological advancement. Now, so far the BSA is concerned, where the electronic evidences and the this all parts are included under the Indian Evidence Act. That is the BSA. Now, the old court practice methods or the old methods of the court practice can be replaced is as soon as possible. So far, the new science and technological advancement which we adopt, so far this particular law is concerned. I think there is an increasement into the power of the police officers, because at so many places the power with the police officer is increased, where they have to exercise the discretionary powers. And if the discretionary is not what we call as a use in a proper way, so it is quite difficult. Now, so far as new offenses, which what I was talking about, that is so far the new offenses is concerned. Now these particular cases is need to go to the Supreme Court and the High Court. Then the new interpretations will come up, and then that particular precedent will be applicable into the given case. Now, what about the old and the earlier decision which is made by the judiciary? So it sometimes it is difficult to apply this particular the problems. Now the logistic support, as I already talk on that, that is we have the very limited sources, we have limited forensic experts, we have limited expert staff so far science and technology is concerned. How many police officers are equipped and having the ability, capability, and the training to handle this particular IT tools in a very systematic way. Now the how many courts having the video conferencing facilities, and there are so many what we call as a logistic support. When we talk about the EFIR, how many police officers are aware about how to go with that particular EFIR is concerned. Now the most difficulty what I personally feel as a teacher, that is learning and the teaching. So far, that is when we are that is discussing this particular part, as Sarthak know very well. I think Sarthak learned the IPC, and now we are teaching the BNS. Sometimes the teacher is confused, sometimes the students are confused, sometimes the teachers and students, there is a gap between two learning and teaching methods. Of course, there is no drastic change as such, but the mindset of the teacher and the student, that is, many students are used to ask, that is, what about the IPC, what about the BNS, and this and that. So that particular kind of the hodgepodge is also the what we called as mm, the challenge before this particular the criminal laws. Now, for what is the remedy for that? What I personally feel, and I conclude within 5 minutes. The most important challenge and the remedy, what I personally feel, that is the mindset. What is the mindset? That is mindset of the all the stakeholders versus trainings. So we need to change our mindset. How many days we will try, we will continue to cry that is the government change this, that, and it is create a problem for us. Okay, let it be. It is already changed. Now we can't do anything. So can we change our mindset? That is, I am talking about the mindset change so far the police and the other stakeholders are concerned, because as the government is taking so much of pain to train this particular staff and the all stakeholders so far, the new criminal law and the amendments and the new terminologies which is used by that particular laws. Now we need to develop the skills to make the balance. That is, when we talk about the skills, so the skill of the police officer, the skill of the other stakeholders who are involved and engaged into this particular kind of the activities. If the skill improvement is there, so far these all peoples are concerned. So of course, I think that this particular law will play a very crucial role. What I that is as a very beginning, I mentioned that is we started the journey from India to that is Bharat, and we are with on the we are looking for the what we call as a speedy justice, accountability, and to change the mindset and to improve the skill. I personally think there is a need to make the huge public awareness about this particular law, because many peoples are not aware about the particular changes which is brought under the in a three laws. So I personally think that if we come, that is, of course, the government is doing very hard to make the awareness and to give the training and the skill improvement and so on and so forth. But as a student of law, it is my and it is our duty to, and I think this conference and this kind of the discussion, debate, and the research will help to spread the awareness, to enhance the skill, because new ideas will come, new peoples will come, and they will give their ideas and their understanding, and they will share their knowledge. And of course, I personally feel that it will provide the help to develop a confidence onto this particular three laws. With these few words, I'm very thankful to the organizers who give me an opportunity to speak on this particular conference. And I'm very sorry that is I could not spare more time with you. But anyway, and I'm thankful to the principal madam and the director sir and the Sarthak specifically for his continuous efforts, and he was talking with me, and he was saying that, sir, you have to commit, and he is my student, so I did not deny him. So I'm very thankful to all the people. Thank you very much.
Thank you so much, sir, for such an enlightening and thoughtful, provoking address. Your insights on the impact of criminal law reforms have truly broadened our understanding. Now, now to bring this meaningful session to close, I request the conference secretary, Mr. Sarthak Aryan, Assistant Professor, IAMR Law College, Ghaziabad, and founder of Equitas Victoria Foundation, to give the vote of thanks.
Hello, am I audible?
Yes,
Yes.
sir.
Thank you. So, it is my great pleasure and a moment of pride that I am able to give and invite my own Professor Amoldev Chauhan sir and our very own AVRC Director Dr. Rangaswamy sir to this conference. listening to Amol sir felt like a nostalgia because in college days we used to continuously meet and disturb him sir for this and that. And organizing these conferences and all, we learned a lot from him only. We were discussing about that. So, and thank you, sir, for sparing your time with us, because your knowledge on new criminal laws and your book on that is has been a very big knowledge source for a lot of people. And I would also like to thank AVIC Director Dr. Rangaswamy sir, because out of such a busy schedule, sir came and he had to attend an offline conference in the morning as a guest. But even then, he attended the valedictory session and represented our research center, Equitas Victoria Research Center. So thank you, sir. Thank you for this, and thank you for all the efforts that Rangaswamy sir did before the conference. And we cannot. I hope, and I also think and presume and learning experience through lot of knowledgeable and resourceful resource person. Lastly, I'd also like to thank IMR management, staff, and all the faculty members. Uh, because it wouldn't have been possible without their effort, uh, especially Minakshi ma'am and from the day host, our day host Anju ma'am, and all the faculties who co-chaired their particular session. So all thanks, because it was a team effort that we did today, and we have been sitting for the whole day with this. So thank you all everyone for this, and I hope this such academic events at IMR continues. So thank you all. Thank you, Amol sir. Thank you, Rangaswamy sir. Thank you,
Thank you,
Minakshi.
thank you, thank you, thank you all. Thank you, madam.
Thank you, sir.
Thank you, all of you.
With this, we conclude the latest session of our national conference. Thank you all for being a part of this academic gathering. Let us continue to contribute meaningful to this legal disclosure in our country. Have a great evening ahead. Thank you all.
Thank you. Thank you.
Thank you.